كلية الفقه الحنفي تقدم
Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome back to the second year of this WISE BA course that is being powered by and taught by White Thread Institute. Allah subhanahu wa ta'ala bless you all. May Allah subhanahu wa ta'ala make this a really prosperous 2 semesters, prosperous year, and may Allah subhanahu wa ta'ala allow us all to benefit from this. Alhamdulillah wa salatu wa salamu ala Sayyidina Muhammad wa ala alihi wa sahbihi ajma'een, amma ba'd. So after praising Allah subhanahu wa ta'ala, sending blessings on the Prophet Muhammad sallallahu alayhi wa sallam, I'm gonna, for this year I've been tasked with teaching some of the jurisprudence, some of the furu' al-fiqh, some of the branches of fiqh as we call it, or substantive law. So this, for this semester and the next one, will be covering topics mostly related to one another, to do with the whole judicial system in Islam. How a judge acts, how a case is brought in, how a case is put in, how a claim is brought in. You know, how somebody can put in a lawsuit, as they say, mostly in America they use the word lawsuit, right? And then how does the witnessing and the proof work? What kind of witnesses can do they have to be qualified as a witness? And who can witness and be witness for whom, and who can't be a witness for whom, even though they may be personally qualified to be a witness, and then those people who cannot be a witness. So that's what it's mostly related to, that we're going to be covering inshallah in this particular semester. And also, if witnesses provide their testimony and then after that they say that they were wrong, or they had made a mistake, or they said that they were false in their original witness, what happens? So as you can see, there's a lot of scope for this, right? There's a lot of scope for this, and it covers many areas of judicial law. And I think the benefit of this is that while most of us are probably never going to become qadis or judges, at least not in a formal sense, we may become, some of us may take on a judge role somewhere, or an arbitrator or a magistrate or something like that. But it helps us, because even in everyday situations, this is very beneficial for us in everyday situations. If we have to deal with a conflict between, two members, two parties, or whatever, this gives us an understanding of how to proceed properly and correctly. And you'll be surprised once you start seeing, how much coverage this has, how much effort has been put into here, how much has been prepared in terms of already being clarified within the law. So inshallah, that's what we're going to be looking at here, inshallah. So to first explain, the chapter that we're going to be covering first is called Kitab al-Da'wa wal-Bayyinat. Da'wa refers to legal claims, lawsuits, and Bayyinat refers to evidences and proof. Right? So we're going to be covering that primarily from Mukhtasar al-Quduri, which, as you know, is a very classic and very popular text. I'm going to be primarily using Imam Maydani's commentary. Imam Maydani was a student of Ibn Abidin al-Shami rahimahumullah. May Allah bless them both and have mercy on them both. And I really like his commentary. There's multiple commentaries of the Quduri. This one, I think it's more balanced in the sense that it provides a lot more information. We're not going to necessarily cover everything from the Lubab because we won't have the time to do that. I'm going to cover the main aspects, but we'll cover Quduri, what Mukhtasar al-Quduri, the Matan, explains to us. This chapter, Kitab al-Da'wat wal-Bayyinat, pretty much is found in most other, extensive books on fiqh and mutun, most of them, right? No, it won't be found in Nur al-Idha, for example. And then it will be found in even the Majalla, right? For example, the Majalla, the Ottoman Majalla that they had produced, it's in there as well. And that's why if you want to supplement this study by looking into other books, it's in Hidayah, it's in all of these other classical books. So you can go ahead and read all of that as well. Of course, as I mentioned, this is not an everyday issue, so you're not going to find that much of that much understanding of it in English. However, as you can see, it is there. And I'll just explain to you the concepts of da'wah and bayyinat first, so that we understand where we're going with this, and I'll give you an overall scope of how the basic Islamic jurisprudence of the judicial case in court works. So you get an outline, and then we can build into that all of the details. Inshallah, that will make this life, that will make this study very, very easy. We ask Allah subhanahu wa ta'ala for assistance, and we ask Allah for benefit. So firstly, the word da'wah, right? Dal, ayn, waw, with a standing alif, right? Da'wah. This term usually refers to a legal claim or lawsuit. In the context of Islamic jurisprudence, it represents usually the formal process. It's a formal process, right? By which a person makes a legal complaint or claim before a judge in an Islamic court, right? There's very particular ways of doing this. That's why it's saying it's a very formal process. The da'wah initiates legal proceedings. You can't have a case without a da'wah. You need a claim, right? What are we going to be arbitrating for? What are we going to be trying to judge? So you need a legal claim first. So that's why the da'wah is actually very, very important in that regard, right? The da'wah is very, very important in that regard, so that it kicks off the whole process, and then the judge and the court system has to deal with it. So the da'wah initiates the legal proceedings where the plaintiff, now the plaintiff here is the mudda'i. In Arabic you'll hear these words very often. Mudda'i means the one making the da'wah, the one making the claim. The technical language for that is the plaintiff or the claimant, right? Plaintiff or the claimant, he seeks a resolution. So the plaintiff, him or her, right, seeks a resolution or justice for a perceived wrong or an infringement of their right. So they'll go to court for that to get their right back, and this process usually involves presenting evidence. So they're going to have to present, and I'll explain this to you once I've gone through the definition, I'll explain the process, right? So they usually present evidence and arguments to substantiate their claim, right? Now they need evidence, so that's the bayyinat section. So usually these two aspects are brought together in the chapters Kitab al-Da'wah wal Bayyinat. Al-Bayyinat refers to clear evidence or proof presented in a legal case. It has to be very clear. There can't be any doubt in this, right? So, pretty much dominantly truthful or dominantly accurate, usually 100% accurate. It encompasses all forms of admissible evidence in Islamic law, such as witness testimony, documents, or other means that establishes the truth of a claim or defense. Now, in our law, the strength and clarity of the bayyinat are crucial in determining the outcome of a legal dispute, as they serve as the foundation of the judge's decision. Now, subhanallah, you'll see the process, right? The judge is bound to the evidence. Sometimes, even if he knows something different, if the evidence is presented before him, he can't go with his feelings. There's a very, very rigorous process. It's a very simple process, actually. And once that's fulfilled, the judge has to decide. The judge has to make a decision. He can't then go with some other prior knowledge or something like that. That's why the Prophet ﷺ once warned that sometimes some of you may come to me for a case, a resolution, and some of you may be more eloquent, more convincing in their speech than the other, and I may judge according to that, because it's overwhelming evidence, at least on the face of it. But if that turns out to be incorrect, and it's incorrect, then all you're doing is you're just securing for yourself a piece of the hellfire. So you'll see how this is played out sometimes, right? So that's essentially what it is. And as I said, both of these concepts are very central to the whole Islamic process, the legal process, where establishing the validity of the claim and the defenses hinges on the clear presentation and assessment of the evidence, right? So having said that, now let me move on to you in the next few minutes to discuss the basic outline of this. So as we said, you need a da'wah or a claim. Somebody brings in a claim that so-and-so owes me £1,000, right? $200, $2,000, whatever it is. and they're not paying it to me. They're saying they don't owe it to me. Of course, if you go to court and say they owe me £1,000, and the other person agrees, then there's no case because the guy's agreeing, right? Then it might be a case of chasing the person for it. That would be a different case. So cases have to be very, very clear. So you put in the case, the judge sets a date, and the defendant, the one the accusation is made against, your adversary, right? Imagine if you're the claimant, then your adversary as such, your opponent, right? The defendant, these are different names. The judge will put the claim through to say that you, Sulaiman, are making a claim against Yusuf that you owe him £1,000, and Sulaiman says that you owe him £1,000. That's his claim, and Yusuf is saying, no, I don't owe him anything. I don't owe him anything. So what the judge will do is he will tell Sulaiman to provide evidence. That's the first port of call. Okay, what is your evidence? Now, there's a certain quantum of evidence. There's certain criteria for evidence. Usually 2 male witnesses, in this particular case at least, or 1 male and 2 female witnesses, right? Or some irrefutable documents, or whatever the case is. If he's able to present the evidence, the case is done. Then it's imposed on the other person that yes, you do owe him and you better pay him. So the case is very clear. It's known. It's recorded that Yusuf owes Sulaiman. Now, usually if it's so clear cut, then in many cases you probably don't have to take it to court because it's obviously proven anyway. A lot of the time the problem is that we don't have enough evidence. So they may just have 1 witness, or they may have ambiguous data or document or something like that. So what do you do now? The judge asks Sulaiman, bring your proof. Sulaiman doesn't have any proof, or he has half proof, or he has vague proof, or inconclusive proof. What do you do then? Does that mean the case gets thrown out of court? No. This is where the next step comes in. The judge will turn around to Yusuf now and say, okay, fine, he doesn't have any evidence, but the way to now exonerate yourself and free yourself is that you swear an oath. That's what they call the tahlif, to have him swear the oath. So if Sulaiman, what's the oath? The oath is, Wallahi, I do not owe him any money. I do not owe him. It'll be very particular words based on the claim, right? So, Wallahi, I do not owe him £1,000, for example. If he's willing to swear the oath and he swears the oath, then the case is withdrawn. It's gone out of court. It's thrown out. The claimant will have to try something else, but it's not going to work this way because he didn't have any proof, and he also had the other possibility of the person swearing the oath. The guy swore the oath. Yusuf swore the oath. Now, if he swore it falsely, obviously he's sinful for that, but that's all we can do because there's no proof. Otherwise, the qadi has to go with what's apparent in front of him. This is very important to understand. The qadi, the judge, has to go with what's apparent in front of them. Now, in the case that Sulaiman is like, no, I can't swear an oath because he could not swear an oath. Yusuf, I'm not going to swear an oath. Could be for multiple reasons. That I can't swear an oath because I do owe him and I don't want to be guilty and sinful in front of Allah subhanahu wa ta'ala. So he refuses to swear the oath. So if he refuses to swear the oath, then that means what the claim of Sulaiman was correct, and the decision is made now that yes, Yusuf does owe him because he's refused to swear the oath. You call that nukul. He's refused to swear the oath. He's avoided swearing the oath. Now, he could avoid swearing the oath for multiple other reasons. It could be because I just don't want to take the name of Allah for something insignificant. £1,000 is not much. You know what? I'm not going to swear the oath. This has happened in multiple cases. I'm not going to swear the oath. I'll give him the 1,000. Swearing the oath, or refusing to swear the oath doesn't prove you're guilty, but it does impose the haqq on you, right? In a sense, it does impose the right on you and the claim is imposed. But you could have multiple reasons. So we're not saying that you're sinful for that, right? Or whatever the case, you could have other reasons for that. So keep that in mind. So as we said, he could swear for, he could avoid swearing for multiple reasons, and we'll cover that inshallah. Now what we'll do is, so now what happens is, then usually in the Hanafi madhab, the case is thrown out. The Shafi'is have one additional step usually, right? Which is that it's brought back to the claimant, Sulaiman. Okay, now you swear the oath. That because you don't have any proof, Yes, you're claiming, but you swear the oath that he does owe you the £1,000. Hanafi say that no, the hadith is very, very clear, and we'll present the hadith to you soon. It's very, very clear that the swearing the oath is the responsibility of the defendant, not the claimant, not the plaintiff. The plaintiff has to bring evidence. If he can't bring evidence, there's nothing else that he can do. You can't also say that if he's only got one evidence, like one witness, that's something that others have a view on, which is that if the claimant has only one witness, can he use that one witness along with causing the other side, the defendant, to swear an oath and then judge it on that? No. In the Hanafi madhab, that won't work either. The Hanafi school is very strict that you either bring proper proof, or it then turns around to be fully on the defendant to just swear the oath, and then that's it. It doesn't come back to the plaintiff. So hopefully that's clear. Now let us start with Imam Quduri. Imam Quduri, may Allah bless him, may Allah reward him, and may Allah reward all of those who've actually been a means to get Quduri down to us, which means all of those who've written the text, produced the text, edited the text, commented on the text, and thus all of our teachers and grand teachers all the way up to Imam Quduri, right? May Allah subhanahu wa ta'ala reward all of them. And yeah, so let's begin now. Kitab al-Da'wa wal-Bayyinat. He starts off with, he says, Da'wa, I've already explained it to you in a sense. He's saying the Da'wa is used as the word fatwa, right? This is what Imam Maidani is clarifying. Da'wa, fatwa, they both on the same scale, they both sound similar. And Da'wa is a feminine word. It won't have a tanween, so it won't, its jama and plural is going to be da'awi, da'wa, da'awi, right? Just like fatawi, we have fatwa and fatawi, and fatwa, fatawa, fatawi, da'awa, da'awi, we have both of those actually, da'awa, right? So it is, in a very simple linguistic meaning of da'wah, is a statement by which a person intends to impose a right upon another. So it's a statement, a claim by which a person wishes to impose a claim on somebody else. The technical definition of that, right? The technical definition of that is إخبار بحق له على غيره عند الحاكم, right? So it's a report, or it's information regarding a right of his upon another person, right, in front of the judge. So it has to take place in front of a judge of some sort, right? The author, Imam Quduri, he starts off with defining first who the mudda'i is, the claimant is, and who the mudda'a alayh, or the defendant, is, because they are the main players in this chapter. They are the main players in this whole category of masail. Without a plaintiff, without a claimant, without a defendant, you're not going to have a system, right? The judge doesn't go around looking for laws to apply, right? There's usually a claimant, in this case at least, right? So even in the case of police taking you, the police are the claimants. If the government is suing somebody, then they're the claimant, they're the plaintiffs. So it's usually always to do with plaintiffs. So in Arabic, the word for that is mudda'i, comes from the concept of iddi'a. Iddi'a means to claim. So mudda'i is the claimer, the claimant as such, and mudda'a alayhi is the one upon whom the claim is made. So it's very simple. The longer word mudda'a alayhi is the defendant, the one who is being accused, and mudda'i is the accuser. Right. So he says, Al-Mudda'i man la yujbar ala al-khusumati idha tarakaha li'annahu talib. Subhanallah. What an interesting definition, Imam Quduri. He takes it from a complete different perspective. This is really interesting. He says that the Mudda'i is the one who cannot be forced, who cannot be compelled to come to the dispute if he wishes to abandon it, because he's the one who seeks it. Subhanallah, what a way to look at that. essentially saying that this is actually a relative definition, in the sense that it's a comparative definition. The mudda'a alayh is forced to come to court. If somebody accuses somebody, they're forced to come to court to represent themselves, or they have to send somebody to represent them, right? So they're forced, they're compelled to go to court, right, once the case is put in. But the person who's putting in the case, the mudda'i, he's not obliged to put in a case. He can just withdraw it and then he's done. He can go to sleep. There's no problem. Right? So that's how he defines it in comparison to the mudda'a alayh, right? I'm not sure if that's the best definition, but it's definitely an accurate definition, in the sense that the mudda'i is the one who cannot be compelled to the dispute, to take on the dispute if he wishes to abandon it. He's the one who brought it in the first place. He can abandon it because he's the one who brought it in. The mudda'a alayh, on the other hand, the defendant, is man yujbar al khusuma, who is compelled to turn up to deal with the dispute, because he has to free himself, or he has to plead guilty and say, yes, it is what it is, right? Okay, so there are a number of other definitions in the Hidayah, etc., which is our fiqh book. For example, regarding the mudda'i, another definition is man la yastahiq illa bi hujjatin. Another way to define it, and you'll understand that all of these are correct. They're just different ways of different aspects of it. It's the one, so the mudda'i, the defendant, is the one who is not entitled except by providing evidence. Meaning he can only be proven as being entitled and win his case if he has proof. And the mudda'a alayh, the defendant, is the one who can actually become liable just by his statement. He doesn't have to prove he doesn't have to provide any proof. See, the mudda'i has to provide a proof. He can't just make a claim and expect to win. He has to provide proof. Whereas the mudda'i, the defendant, can say, yes, I'm guilty. He doesn't have to prove that. Not to prove you're guilty. He doesn't have to do that. So just his statements are sufficient. That's another way to understand it, right? It doesn't get to the core of it, but it gives you an aspect of it. Okay, another definition. I think these are really interesting because it gives you an understanding how fiqh works and how they look at different aspects of something. And I said these are all correct. Another one is that the mudda'i is the one who is trying to seek out something, to pursue something which is not apparent. Because if it was clear and apparent and fixed and proven, then you wouldn't have to take that to court. It'd already be proven anyway. And the mudda'a alayh is the one who is more, and I think I'll explain this because this will come into use afterwards, is مَن يَتَمَسَّكُ بِالظَّاهِرِ. He is the one who is adhering to and more in conformance to what's apparent right now. Okay, what does that mean? For example, if I claim that you owe me 1,000, there's no money there, there's no proof there, right? And the zahir is usually that people aren't born owing other people. So if we just left it as a default situation where somebody was born and grew up, you don't owe anybody anything by default. The only way you can owe me something is if you took something off me, or we made a deal or a contract or an agreement, right? So really, if you look at the default is that there's no obligation. So the mudda'a alayh is on that position. Doesn't make him stronger necessarily, but that's his position. It's just another way of looking at it. Whereas the mudda'i, the claimant, is claiming that no, you do owe me. You went against your normal default. You took money off me. We made an agreement. That's why you owe me £1,000. So I better prove that, because that's something extra over and beyond the default of not owing somebody by default. People don't owe people things by default, right? You have to have made an agreement or done something, usurped something, inappropriated something to do, to become liable. That's why Imam Muhammad, rahimahullah, in his asl, says that a mudda'a alayh is usually the denier. It's another way of saying denier of that extra that you're trying to impose on him, right? He's the denier. Okay, so that gives you a good understanding of the definitions, and we can move on to the shurut, inshallah. So, Bismillah, the next section is Shurutu Qubul al-Da'wa. What are the conditions for a claim being upheld, or a claim, you can say, being even accepted in court? Does the judge have to take on every claim that comes through and waste everybody's time? It may be a, it may be a farce. It may be just a fake claim. It may be just wasting somebody's time. What is it? What's going on? So that's why he's saying that these are the shara'it and of accepting a claim. وَلَا تُقْبَلُ الدَّعْوَى حَتَّى يَذْكُرَ شَيْئًا مَعْلُومًا فِي جِنْسِهِ وَقَدْرِهِ. You can't just go and say, I've got a claim against him. You can't do that. You have to detail what your claim is exactly. It has to be very clear. That's why from the claimant, the claim can't be accepted, right? And you can't force the defendant to come in until the claimant makes very clear and mentions something very specific in terms of its category. Like, what is it? What is the category of this claim? Is it a right that he took? Does he owe you something? Does he owe you money? Does he owe you rice? You did a deal with him and he didn't supply the rice to you. He was a distributor of rice, for example, or gold or silver or money or whatever it is. And then obviously the amount. You can't just say, he owes me some rice. He owes me some money. That's very difficult, right? So it's this much, this amount, this number. That's very, very important. Now, if the claim is regarding, right, if the claim, so the word mudda'a bihi, right, that's a third term which I didn't explain before. Mudda'a bihi is the thing which is being claimed. So mudda'a alayhi is the one upon whom the claim is being targeted, or upon whom the claim is being, directed. But mudda'a bihi, and I'm not going to use that too much to not confuse you, but mudda'a bihi refers to the claim itself. What is the claim? Right? If the claim then is something like a laptop or a phone or a car in the hands of the defendant, that he has it, right? That car is mine, right? So in the case that the case is going to go forward, he'll have to bring that in court. Of course, if it's a car, he can't bring it in court, but he'll have to bring it outside or somewhere of that nature. Of course, if it's a piece of land, that's not done that way. But it's made very, very clear so that we know exactly what the claim is about, so that there can't be any confusion. Oh, you meant that laptop, not this one, So it has to be لِيُشِيرَ إِلَيْهَا بِالدَّعْوَى. That's so that it can be indicated and pointed at and specified with the claim that, yes, it's this one that we're talking about, right? Because we need to make this as clear and as quick as possible, and this is the best way to do it. That's why it's important that the object, the item of claim that is under claim is also brought in. وَإِن لَمْ تَكُنْ حَاضِرَةً, he says, if that item is not present, in the sense that it's already perished. Oh, he owed me, this, he took my phone and the phone got destroyed, for example, right? Or it's going to cost to bring it over because it's very heavy and it's going to require you to hire a service to bring it in. ذَكَرَ قِيمَتَهَا. So in that case, there are alternatives. You just mention the price, the value of it. So that makes it clear that, oh yeah, it's that £700 laptop, that $1,000 laptop. It's not the other one, right, which is the $200 laptop. Right? Because that provides a substantial idea, right? Now, on the other hand, if it's a piece of land, then there's lots of claims of land claims between brothers and family members, right? So if it is وَإِنِ ادَّعَى عَقَارًا حَدَّدَهُ, in that case, you obviously don't bring the land. You don't even have to go to the land and set up a judiciary there. You just حَدَّدَهُ, which means you demonstrate, you express its limits, right? Because you can't always point towards it, but you express its limit. What does that mean? You show how large it is and who the neighbors are on all the sides. And it's quite detailed in the sense that you have to actually mention, to make it very specific as to which land you're talking about, you have to actually mention all of your neighbors. So if you have 4 neighbors, you have to mention, okay, that one is owned by X, Y, and Z. And you can't just mention one name. They said you have to actually mention his grandfather's name as well. Now, nowadays, that might be a bit different because you have deeds and there's other ways to show this and demonstrate this, and there's maps, and it's a lot clearer, right? So maybe they've got an updated process in this, but the classic books, this is what it says, that you have to mention who your neighbors are, and there has to be full detail about them, so you know exactly which piece of land we're arguing about, right, that the dispute is about, right? وَذَكَرَ أَنَّهُ فِي يَدِ الْمُدَّعَ عَلَيْهِ. So that's the next point, right? Another point is, so number one, it has to be a clear da'wah. It has to be a clear da'wah in the sense that the claim has to be very clear as to what it involves, and what's included in that, and which land it is, and which piece of furniture it is, or whatever it is. And number two, the second thing that has to be very clear, وَذَكَرَ أَنَّهُ فِي يَدِ الْمُدَّعَ عَلَيْهِ. He has to claim, the plaintiff has to claim that it is in the control or the possession of the defendant. If it's in my own possession, why am I claiming, right? That would be, then he would have to claim that it's his. The opponent has to be. In this case, it's my claim against him, and he has it. So I have to actually mention that it's in his possession. That's the way that he becomes my opponent. Otherwise, why is he my opponent if he doesn't have it, right? So now there's a bit of discussion here that so the way to make him the person who your claim is against is obviously to say that he has it. It's not sufficient for the defendant to say, yes, I do have it, but that has to be also established that he has it, right? Or the judge should know that he has it. So if he's got some personal knowledge that, yes, he's been driving around with that car, right, that I know it's in his possession, then that's okay. Because sometimes you might bring you might bring a case against somebody, whereas it's another person who has possession of it. Okay, number three, وَأَنَّهُ يُطَالِبُهُ بِهِ. The third thing you have to then declare in court, officially, formally, is that I am demanding it from him because it's mine. So not only do you say that this is my case and it's in his possession, but you say, and I want it back, and I want to assert my right over it. So because it is possible that you may have given it to him for another reason, like you may have given it to him as a collateral for some money that you owe him, and he's not giving it back because you're not giving him the £1,000 back. It's your laptop, and you gave it to him as security, and now you're not giving him £1,000 back, so he's withholding it to get his money back, and you're going to court to say he's got my laptop, right? So it has to become very, very clear on what basis are you trying to seek to get this back. Okay, then he says وَإِنْ كَانَ I'm going to read a bit of Lubab with it when it's just a bit. وَإِنْ كَانَ الْمُدَّعَى بِهِ حَقًّا أَيْ دَيْنٍ فِي الذِّمَّةِ ذَكَرَ أَنَّهُ يُطَالِبُ بِهِ. And of course, if it's not an item, like a physical item, but rather it's a debt that he owes me £1,000, right? Then you can't bring the £1,000 here, because that's just something that is owed, right, as a liability. So in that case, you just have to still, the plaintiff still has to mention that I seek this, I demand it back. Okay, what does the judge do now, right? The judge, once he sees that فَإِذَا صَحَّتِ الدَّعْوَى مِنَ الْمُدَّعِي سَأَلَ الْقَاضِيَ الْمُدَّعَى عَلَيْهِ عَنْهَا, right? Once the judge sees that, yes, this is a proper claim, and he is making the claim, he's done all of his formalities, the qadi, the judge, will ask the defendant, will ask some questions. Yes, do you owe him that? Is this correct? Is this his? فَإِنْ اعْتَرَفَ بِدَعْوَهُ. If he confesses that yes, he's correct, قَضَى عَلَيْهِ بِهَا. That's easiest. That would be a very easy case. Then the judge just makes the judgment that yes, he owes him £1,000. The guy said yes, right? Right. وَإِنْ أَنْكَرَ. However, if he refuses and he says no, I don't owe him anything, سَعَلَ الْمُدَّعِيَ الْبَيِّنَ. Now he turns back to the claimant and says, okay, what's your evidence? Because he's refusing to accept, so you need evidence. So what is your proof? If he provides the evidence, which means that he provides solid evidence of two male or one male and two female in a money issue, for example. We're going to discuss later how many witnesses have to be produced. So it could be different in different cases, right? If he produces the correct number of witnesses, قَضَى بِهَا, then again, the judge, is very simple. The judge can make the decision and he will make a judgment that he does owe him, because by bringing proof, then you can see that he is truthful. Right, now this is the case, as I explained earlier, when he's not able to provide indisputable proof like that. وَإِنْ عَجَزَ عَنْ ذَلِكَ وَطَلَبَ يَمِينَ خَصْمِهِ اسْتَحْلَفَهُ الْقَاضِي عَلَيْهَا. If he doesn't have the proof, he doesn't have the evidence, he can then seek from, because he can still give up right now and he can say, okay, fine, I don't have it, but he's taken it all this far. He can now ask the judge to ask the opponent to swear the oath, to say, I don't owe him anything, because in Islam, that oath aspect obviously is to do with the faith, right? Because if you don't have faith on anything, why would you swear an oath? It's got a lot to do with personal integrity and the aspect of, feeling that you owe somebody something, right? And you have somebody that you're accountable for, which is usually a god, right? Which is a deity that you believe in. So to just finish this off and then to conclude it for this lesson, right? So then, istahlafahu alayha. And it's actually necessary. The qadi doesn't just do this automatically. The plaintiff has to ask the judge to make him swear the oath. وَلَا بُدَّ مِنْ طَلَبِهِ لِأَنَّ الْيَمِينَ حَقُّ, because it's his right. Meaning the defendant, not the plaintiff's right to, if he doesn't have proof, to at least get the other guy to swear the oath. So he has to ask him to do that. Yeah, the only case where the judge would do this without the defendant asking is if it was upon a mayyit, if it was to do with a deceased person. We're not going to go into that right now. Right. Now, if the mudda'i says, meaning the claimant says, li bayyinatun hadira. Now, it could be that he's got proof, but it's not present there. Or it's away, or it's not present right there, but it is in town. So if he says li bayyinatun hadiratun, meaning fil misri, in the city, wa talab al yamina lam yustahlaf inda Abi Hanifa. According to Abu Hanifa, if the plaintiff comes in, the claimant comes in and says, I do have evidence, it's not here right now, I've got evidence though, believe me, I've got evidence, but I want him to just swear the oath, let's just make this easy, right? According to Imam Abu Hanifa, that's not right. You can't force the other person to swear an oath without him bringing his evidence just like that. Yeah, if he doesn't have evidence, then it's fine. But if he's got evidence, then he can't force the other guy to swear an oath if he confesses that he does have evidence. Whereas according to Imam Yusuf, it's a difference of opinion. He does have the right to demand an oath even without his evidence, because he could have just said, I don't have evidence. So he takes it from that perspective, that I don't have evidence. I could have just said that anyway. I want him to swear an oath. So he will have to respond to that. Right. وَلَا تُرَدُّ الْيَمِينُ عَلَى الْمُدَّعِي. Now, if he is not willing to swear, swear, then you can't, if he refuses to swear, you can't bring that back on the claimant. As we mentioned, وَلَا تُرَدُّ الْيَمِينُ عَلَى الْمُدَّعِي. The oath does not come back upon the claimant, in the sense that now he has to, he can swear an oath for anything, makes no difference for that. And the reason for that, as I said, I promise I'd mention to you, is al-bayyinatu ala al-mudda'i wal-yaminu ala man ankar, is because the hadith is very clear that al-bayyina, which is the proof, is the responsibility of the claimant, and the yameen, which means the oath, is the responsibility of the one who is the defendant, meaning the one who is denying responsibility. So the Prophet ﷺ has very clearly demarcated each person's role and responsibility. So you can't switch that around. Likewise, there's another hadith, ash-shahidu wal-yameen, right? There is a hadith which we'll describe in the next lesson, which others use to prove that it can happen. We'll respond to that, inshallah. Jazakallahu khairan. May Allah subhanahu wa ta'ala bless you all. We'll see you in the next lesson. Assalamu alaikum wa rahmatullah.